during the process, the attorney said something I thought was really awesome. Said that when you are giving your notice to creditors and the claims are coming in, make sure you negotiate every claim, because with her experience, many debt collectors will settle for pennies to the dollar, particularly if it's a decedent's account. So I was wondering if there's any tips or strategies that you can provide when it comes to speaking to debt and creditors about negotiating the debt down the estate.
Sure, and this is very state specific. What state are you in, Courtney?
North Carolina.
Got it. Okay. So every state is slightly different, right? California is unique in that there are a few rules that make it a little more challenging for creditors, actually, a little easier for us to negotiate things than there are in certain other states. For example, in California, there is a 1-year statute of limitations on the collection of debt from a decedent, regardless if an estate was opened or not. Very interesting, very weird sort of rule when you look at some of the others. Other groups. So you have to look at kind of what that is. But I agree with that attorney completely. You can negotiate those debts. You can look at them, and that really drives higher dollars in the door for the beneficiaries, right? I mean, and that's something, whether you get involved in that in the sale of real estate perspective, or however you're in that. Those types of little things are super important. And, just like in bankruptcy, a little bit of pushback from the estate can oftentimes result in them not even pursuing the claim at all. Because, depending on how much it is, it might not be worth it to them. If they're only owed $1,500, $2,000, they're probably not going to get a lawyer. They're not going to go in and file the claim. They're not going to do this. They're not going to do that. You do that 2 or 3 times, you've now netted the estate, $10,000, right? Or something like that. So it can be it can move the needle a lot. Great question.